Hey everybody, welcome to today's webinar on cannabis receiverships. My name is 𝗱𝗶𝘀𝗂𝗀𝗋. I'm sitting here with these two very knowledgeable, very stylish gentlemen. You'll see Matt Goldberg. He's on my left, the guy with the pink shirt. 𝗱𝗵𝗶𝘀𝗂𝗀𝗋 is the guy with the blue blazer. I'm sitting here in Portland, Oregon. Matt's in Portland too, but we're not at our office because they're doing roofing and seismic work. So you're looking at my basement. I don't know what room in Matt's house. And I'm going to let them self-introduce a little bit better in just a second. I'll introduce myself. I am a business lawyer. I'm not a receivership or insolvency or debtor creditor lawyer, any of those things, but I work with a lot of businesses that unfortunately have come up against this. So I've helped people through restructures, and when it gets bad enough, sometimes I'll turn them over to Matt or Ethan or somebody like that. So without further ado, do you guys mind just giving a brief blurb bio on yourselves? I'll start with you, Matt.
Sure. Thanks, Vince. Hi, everybody. Thanks for coming. I'm Matt Goldberg. I started out life, my lawyer life, that is, as an insolvency bankruptcy lawyer, representing mostly Chapter 7 trustees and creditors. And through that, I was introduced to commercial litigation and corporate law and real estate law, sort of through the insolvency lens. And then, as some of you know, about 10 years ago, got into the civil cannabis sort of business law space, and it's taken a solid 10 years for the insolvency receivership world and the legal cannabis world to finally start coming together in a way where there's enough activity that you could even talk about it. And so that's sort of why I happen to be sitting to Vince's left wearing a pink shirt.
How about you, Ethan?
Hi, I'm 𝗱𝗵𝗶𝘀𝗂𝗀𝗋. I'm similar to Matt in that I spent a significant portion of my career doing corporate insolvency work. I primarily represented senior secured lenders in various insolvency proceedings, primarily bankruptcies and receiverships around the United States. At least out in Arizona, that practice area died around 2013 or 14. And really the most prevalent form of insolvency proceedings out here now are receiverships that we see more often. Arizona is a bit of the Wild West. We don't have a very comprehensive statutory scheme. So things can get a little, I guess, more wild in Arizona.
Great. Okay, so before we kick it off, I'm going to just say one or two things. The first is that we have several of you who submitted questions in advance, and I appreciate that. And we'll get to as many of them as we can. But if something comes up or you're just thinking of a question now, feel free to type it in, and we will see it in the comments. We may or may not answer it. We'll try to get to everything we can. The other thing I'm going to say is we're not giving legal advice today. For those of you, whether you're our client or not our client, if you're our client here, we're not giving you legal advice in this context that waives privilege. So we're just talking. And anything that we say today is just designed to basically be educational in nature. So I want to start with the basics because half the time I mention receivership and people look at me like, what are you even talking about? What is a receivership and how does it differ from bankruptcy? Ethan, I'm going to give that one to you.
Yeah, receivership, I mean, there's both state and federal law receiverships. I think state law receiverships are much more prevalent than federal. I mean, you would see a federal receivership if a borrower has assets in multiple states, right? And you don't have a state court that has jurisdiction over all of those assets. Receiverships, at least in my experience, are much different than a bankruptcy. A bankruptcy proceeding, you have the bankruptcy code. It's a comprehensive code. There's a tremendous amount of case law around the bankruptcy code and interpreting various provisions. At least in receivership law, it's a carryover from Old English law. And if you go back and look at various treatises, as well as the case law, oftentimes you can trace it back to Old English times. But there are some good treatises. I think there's one called Clark's on Receivers, which is excellent. But the amount of variability across the U.S. is pretty, staggering in terms of receiverships. You have states with very comprehensive receivership statutes. I don't know if Oregon qualifies as such. I know California has a pretty comprehensive set. And then you have states like Arizona where, there's not much. And really, the order of appointing the receiver is really what controls the entire case here. So it's at least in my experience, while it's a powerful remedy and a remedy that often makes sense given the circumstances, it's just not as powerful as a bankruptcy.
Sounds good. Thanks for that rundown. I have a follow-on question, then maybe Matt could handle this. What's different or unique about a cannabis receivership as compared to any other commodity or type of business?
It's a good question. I mean, there are a couple of things. I mean, number one is the sort of obvious one, which is that at least as of now, we're still dealing with a Schedule I substance that if we're talking about a business that touches the plant in one way or another, then you're talking about a case where either a receiver, I was going to say either a receiver or a trustee, but that's a good place for me to say it's not either a receiver or a bankruptcy trustee if you're a plant touching company, because that is precisely why the receivership option is the one that we're exploring here and that people are using. You can't really be in bankruptcy court with a business that makes money trafficking, as that's defined, in a controlled substance. And I believe that's going to be off limits for as long as it's Schedule I, certainly. So that's one part of it. Another part that goes with that is that it's heavily regulated and licensed. And so in Oregon, for example, and I'm not aware of others, I've done so many real estate receiverships, for example, over the years, and this never is an issue there. But in Oregon, there's a provision in the statute and in the administrative rules that speaks specifically to how a receiver can work with the agency to obtain the ability to manage the licensed premises and the business. And that angle is not typically one that you have to worry about in a receivership. So it's not just you're dealing with the license and getting permission to use it, but you're also still dealing with something that's federally illegal. And that's a pretty unique combination.
I have a couple of follow-on questions that both came from the audience that are related to the second part of what you said. So the first one is short and sweet. Does the receiver need to hold his cannabis license? And then the second one, somebody from the state of Connecticut is asking, what should government regulators consider when drafting legislation to address receiver licensing language?
It's a great question.
I think for the okay.
Yeah, go ahead. No, please go ahead.
No, I think for the first question, at least in my experience, the receiver doesn't have to hold a license, and typically the receiver would work under the license that's already been issued to the entity. But with that being said, I think they have to qualify as any other interested party would have to qualify, under state law to be able to touch the cannabis. Typically you go through various licensing requirements, even for the individuals involved in the cannabis operation. So I think state law would likely mandate that, but the notion that a receiver would have to hold his or her own individual license, I've never seen that requirement before.
And what about considerations then, Matt, for government regulators who are sort of trying to build an architecture in their program for receiverships and businesses that fail?
So my first comment about that actually doesn't seem like it's about receiverships, but it really is. Most of the time, I see there's a question about, who is a party and interest in a receivership such that that party could initiate a receivership or participate in a receivership, and that's sort of related to this in a way also. Generally speaking, a landlord, a customer, a creditor, potentially even an equity security holder could initiate a receivership. But the truth of the matter is, what tends to happen a great majority of the time is that the entity seeking the appointment of the receiver is and often the senior secured party. And as a result, the relationship between the security interests in the assets of what I'll call the debtor or the entity that's going into receivership, those statutory provisions, be they in the state's enactment of Article 9 of the ECC or in the cannabis, specific legislation, I think Oregon does a good job of calling out in the statute and in the administrative rules that it's contemplated that a secured creditor might get a judgment or a receiver appointed, and in that instance, it's appropriate for that party to have the same general rights and remedies that it would have if the collateral was something other than a cannabis license or cannabis material. And so I think making sure it's not just about what the receivership statute or rules provide, it's also sort of in those other areas that touch it, making sure that those areas are sort of as receiver friendly as possible, if that makes sense.
I was going to pick up on one comment that Matt made when he was talking about who typically appoints the receiver in a cannabis case. At least in Arizona, again, we don't have any statutes, but we do have a corporate statute that if there is a deadlock for a company, that the appointment of a receiver is an appropriate remedy. And that's often, at least in Arizona, how you end up in a receivership matter. Now, we likewise have statutes or the ability to appoint a receiver if you have a secured lender involved and there's been a default. And actually in 2020, Arizona introduced new legislation that's been passed that we now have separate statutes for commercial real estate that are actually pretty comprehensive. But in this instance, when it comes to cannabis, I think it's more typical that you would see a partnership dispute that would essentially initiate receivership matter.
Hey, Vince.
Yeah.
Can I jump in and addressing two things that I see in the comments?
Yeah, no, I see them too. Yeah, go ahead. Anything you think is interesting there?
So there are a couple questions that to me suggest something. So one comment is a question: how long does the quote unquote taint of cannabis follow the assets? And there was another one here about the number of receiverships, state law receiverships growing, and why that might be. And what I think is interesting there, I think this is one of the best things about cannabis state law receivership, is that there isn't this federal overlay of you're doing something wrong and your business is bad and you should feel bad about what you're doing. It's like the state cannabis law, the state receivership law, the state, UCC, they're all sort of on par with one another. And this is my experience, at least. You walk into a court and the court just sort of takes it as a given that it's a legal cannabis business in the state where that judge is a judge, and it's sort of a piece. It doesn't mean every judge that you deal with is going to love cannabis. That isn't what I'm saying. It's just this sort of acknowledgement that it's real, it's legal, it's part of what we do here, and it lends itself, for lack of a better way of saying it, to that remedy and to use of that statute, the same as anything else. And as someone who does it on a regular basis, I can tell you that makes some kind of difference. That you're not sort of like, no one talks about Schedule 1 or cares about Schedule anything in that specific context. And I think for the company that's in receivership, going through it, and for actually all the parties that are involved, that's kind of a nice thing that isn't, this nuanced legal point necessarily, but it is something that's worth saying, is that you sort of staying within the scope of the kind of law that creates and respects the cannabis license and business. And I think that's a positive thing, or it can be.
To pick up on one question that came in that Matt touched on in terms of our cannabis receiverships growing, I mean, at least in Arizona, there were a fair number of receiverships that were filed after medical was passed. I think approximately 2010. And I think part of that was you had a lot of small business owners, right? And there were conflicts. And I think as our market has matured, we've seen a lot of MSOs come into the market, a lot of very mature companies. And I think the number of receiverships over time has actually gone down because of that.
Well, and just to be specific, my point in raising that before was I don't think there is a taint to the assets, at least in my experience, when you're in a state court receivership and the business is a state licensed business. You're sort of dealing, I'm not going to say it's widgets because it's not widgets and it's licensed and it's illegal and like things we were saying in the beginning, but it's not really a taint. And people are able to buy and sell and do things in the cannabis receivership, whether it's buying plant touching type material or buying equipment or buying a license. And I don't see that there's any taint, like morally or perception wise, and there also isn't a legal taint.
Sure. I have a question. It's kind of based on what Ethan said earlier about bankruptcy code being kind of comprehensive and statutory and all sorts of case law, and it goes back and back. And receiverships, I think you said the Wild West, for lack of a better word. In bankruptcy, we have all different kinds of bankruptcies, right? We have debtor in possession and just stuff the farms and just a lot of things. Sometimes a business in bankruptcy can kind of go into bankruptcy and come out successfully and exit the bankruptcy. Can that happen in a receivership, or is it just a sell-off process every time?
I mean, I think, it's a great question, actually, whether a company can be reorganized within the receivership matter. Yes, I mean, I think that can happen. I think it's, at least in my experience in receiverships, it's less likely. You typically see a sale of the assets or one partner bowing out and bringing in a new partner. And sometimes there have been, successful reorganizations because, there was a lot of conflict. There may have been fraud involved. You put a receiver in, they kind of iron out the business and, get things up and running again. I think, more like a normal business without those issues. But at least in my experience, it's more typical to see some kind of transaction transpire, or more like a Chapter 7 where you're just going to dispose of the assets and go out of business. It just depends. I mean, right? Is it a viable business concept that just needs some help to kind of make it through a certain period versus, it's just not a good concept, or the market's oversaturated, or whatever the case may be.
Somebody asked a related question to that, which is, how do you go about valuing the business as a whole or its assets when you're in this sell-off process? Who values it? How do they do it?
In my experience,
Go ahead.
No, I've done a fair amount of valuation work, and typically you would bring in an MAI. That's someone who's a member of the Appraisal Institute. The Appraisal Institute is really the gold standard for an appraiser, and they can value assets individually, or they can do an enterprise-wide value. There's other individuals who qualify as an expert in that space as well. You could have brokers, but they don't carry the same weight as someone who has an MAI behind them. And there's various ways and methods that are standard within the MAI world in which you value a business. So that's typically, at least in my experience, if you're going in front of a judge, or if you just want credibility in general, you would pick an MAI appraiser.
And just to approach that from a slightly different perspective, when I first started as a bankruptcy lawyer, I used to hear the the more experienced lawyers say, like, it's worth what the market says it's worth, kind of thing. And none of this means that you don't bring in appraisers and have battles of the experts and that kind of stuff like Ethan is describing, because you do when there's enough at stake. But sort of conceptually, when you're in the receivership world, like in bankruptcy world, this is one way in which I think they're very similar. If you properly notice to the parties in interest, the creditors and whoever else has requested or needs to be noticed, that you as the receiver or trustee intend to sell this asset for this much money to this party, the court's sort of default position is, if proper notice of that is given and no one objects, that's what it's worth. It's worth that much. And to take it even one step further, what I've seen is judges say to someone who comes in objecting to that price, like, hey, that's great. Is your client offering more? Because otherwise not interested in talking about it. Yeah. So and again, none of that's to say that valuation isn't important. It's just to shine a certain light on this process, because something else that's associated with that I want to throw out, because the question is coming up: buying something from a receivership estate or a bankruptcy estate is not the same as buying it in the normal world. And I say it like, because this will solve a lot of problems for people who don't realize this yet. Like, if you're dealing with a receiver or a trustee, take all your reps and warranties and flush them down the tubes, because the receiver's not going to give you those, trustee's not going to give you those, court's not going to give you those. You're not getting those. You're buying whatever you're buying as is, where is, and there's no warranty that it's even what the trustee or receiver says it is, which sounds ridiculous, but it's actually true. And if a sale like that is consummated and the judge signs off on it, it's done. It's over. It's almost impossible to reverse that on appeal, and so that's something to keep in mind. And one thing I want to just reach back to something, the great question from the Connecticut folks about statutes. One of the things that I think is exciting, generally speaking, across time with receiverships in the U.S. is the move toward, or the trend toward, having a more comprehensive statutory scheme under state law for the receivership. And Oregon's a good example, not just because it's where Vince and I happen to be right now. It's also because this happened relatively recently, where for who knows, like many, many decades. I don't know if it's true that it's more than 100 years, but Oregon receiverships were determined solely by a pretty arcane sort of rule of civil procedure that governs provisional process. And like Ethan said earlier, when that was the regime, the order appointing receiver is like, it's the law. It's like private law almost, and that's totally what governs the court's actions. It's what would govern review of different questions on appeal. When you have the more comprehensive statute, however, the order appointing receiver is still very important, obviously, but now all that order is doing is it's just recapitulating what's in the statute. And the things that you tend to have in a comprehensive statute that you don't have otherwise, because outside of this context, there's no way for normal law to provide this, is the idea of an automatic stay, which is really important. And so if you're going to have a receivership statute, then... Can
you explain what a stay is really quickly? I think a lot of people know.
Yeah. Sure. So I say that like it's a given. The automatic stay is one of the defining features of bankruptcy as we, in this country understand it. And it's an injunction, which means it's a court order that you, as a creditor or a landlord or a stockholder or anybody, whatever your claim, whatever your beef is with this debtor, this entity that's going into bankruptcy or receivership, collection activity stops, foreclosure stops, eviction stops, litigation stops, everything pauses. And that pause is called the automatic stay. And it's called automatic because it arises automatically by operation of law, and violating it is a serious business. And you can violate it by doing something that violates it, even if you don't know that you're violating it. If that came out right. So it's something to be super careful of if you're on the other side of an entity that is in bankruptcy or receivership. So that's what the automatic stay is, and it's part and parcel of the U.S. Bankruptcy Code. It's also part of, for example, Washington State's receivership statute and Oregon's receivership statute. And when someone goes and promulgates a receivership code, it tends to look like a mini bankruptcy code in that it doesn't have every bell and whistle that the U.S. Bankruptcy Code has, but it has a bunch of them. And another one that's worth mentioning in the sort of category of importance of the automatic stay is that the receiver had the ability to assume certain contracts of the entity in receivership. The fancy word for that is something called an executory, EXE, executory contract. It just means it's a contract that's sort of in play where both sides still have performance left. So if it's a lease is executory because the tenant still has to pay rent and the landlord still has to provide the space. So that's a classic executory contract. And just to echo what Vince said earlier, if we give examples or I say things, I'm not talking about a case that you think I'm talking about because I'm sort of combining examples and trying to construct things in a way to make certain points. And so all these cases tend to share the same kinds of issues. So I'm not speaking about any particular case, I'm just speaking in general. But if you're having lease issues as a cannabis business, then getting into a receivership where there is an automatic stay and there is the ability to assume or take on or take over a lease that existed before the receivership, well, now you're really talking about, not necessarily reorganizing as much as probably preparing it to sell, with the proceeds going to pay the costs of the receivership and as many creditors as can be paid, in order of priority. But those are some really unique facets to the bankruptcy code, to a receivership statute, that I think can make all the difference in the world.
Do you have a follow-on thought, Ethan? Go ahead.
Oh yeah, in terms of like, at least in Arizona, we don't even have a priority statute. So if you get into a case and there's actually money to be distributed outside of a senior secured lender, whatever the case may be, we don't have a distribution scheme. And so I've had judges actually adopt the bankruptcy code's distribution scheme in the past, because I think some of the judges in my experience, they will look for analogs in the bankruptcy world and see if those can be adopted. And to Matt's point about the automatic stay, Arizona does now have an automatic stay, but it only applies to commercial real estate receiverships, not to just shareholder dispute type. So that is an interesting concept that's been introduced out here. Oh, one last thing. In terms of sales as well, at least in the bankruptcy context, one of the things you have to show the court is that you've got the highest and best bid. And you do that typically by showing you've marketed the asset, if there's other buyers, what they've offered, right? I don't think in general you have the same requirement in a receivership matter, although it's probably smart to do the same, right? At least to market it, try to get the highest and best. And if there is an objection, well, now you've got evidence, right, that I've marketed it, I've done a good job, and this is the best we can do.
Here's a question I get a lot as a business lawyer, and I'm guessing a few people will be interested in this in the audience. I get businesses coming to me all the time and saying, things are not going well. Like, I'm just kind of looking ahead. Cash flow's bad. I'm going to owe a bunch of money on balloon or whatever. I'm struggling to pay rent. Can I put myself into receivership? Can I kind of like just get it in there so I can get away from any sort of whatever consequences? I don't want to get sued. Can I just do this proactively? Can you do that? Or do you need a secured creditor or a creditor or a landlord or anybody to sue you first?
At least in Arizona, it requires a legal action to appoint a receiver. And I'm unaware of being able to sue yourself for the appointment of the receiver. So I've never seen that scenario before where, the party themselves, somehow ask for the appointment of the receiver. But maybe Matt has. I have not seen it.
It's an interesting question. I mean, I think that in the context that you're asking it, Vince, I think the answer is generally no. That you can't like put myself or like my LLC that I own or own most of and the manager of like into its own receivership just to do because I'm worried about people getting paid. As soon as you get into any kind of more advanced corporate structure with intercompany agreements and loans and
Sure.
other sorts of, then the possibility opens up to sort of like, what does it mean to sue yourself, so to speak? And that's a whole sort of discussion that you could go down. But in terms of I don't think that's how it's being asked. And I think the way it's being asked is more like, I'm sort of this business and what can I do? I don't think not only can you not easily put yourself in receivership, I don't think that's really what you want to be doing, because generally speaking, I think the company goes into receivership as a sort of Chapter 7 bankruptcy alternative. And Chapter 7 is the liquidation bankruptcy. Like Ethan said, it's not impossible that a company could come out of a receivership reorganized, but in my experience, that would happen through sort of almost like a workout. It's not out of court if there's a receivership, but it would almost be like, hey, if we figure this all out this way, let's agree and we'll stipulate to terminate the receivership, and then you'll do this and I'll do this and you'll get this. So, I mean, that's something you can definitely do, but if the receivership sort of goes through its entire process, the idea is that all the assets are sold and administered and creditors are paid, the costs of the receiver are paid, and then, it's goodbye, everything's owned by new owners, so to speak.
So you mentioned the creditors are paid, and before Ethan talked a little bit about a preference statute, and I'm kind of curious, do all the creditors get paid out of receivership? Do unsecured creditors ever get paid in a receivership? Who gets paid and how does it work typically?
At least in my experience, the answer really is dependent upon the kind of receivership. In my experience, like I said earlier, in a commercial real estate setting, I filed, I can't tell you how many during the Great Recession. Most were uncontested. No one, the defendant didn't even show up. The secured lender who I represented, had a blanket lien on everything. The property was way underwater. And, that scenario, no one's getting paid other than my client at a steep discount. But in a receivership matter where you have an operating company, and say a partnership dispute, well, the company's still operating, still making money, right? Well, it can still be making money, in which case then you can afford to pay creditors and the like, or at least, at least a portion of what they may be owed. So yes, it does happen, but I think it's highly dependent upon the business type and how it enters receivership.
And what's the typical timeline for a receivership for an operating cannabis company, say? Let's say a secured creditor sues an operating cannabis company, gets an order appointing receiver. Does it take a month, a year, 6 years? Like, how does that play out?
I think it can take it doesn't take a month. It could take a year. It could take 6 months. It could take, there are some bankruptcies, federal bankruptcies that last years and years. Receiverships tend to not last as long. I want to speak for a second to the issue of who gets paid, because it's important to be real about that. And for the benefit of everyone who's on every side of it, the type of receivership that I have the most experience with in terms of number of receiverships done is the type of stuff that I used to do during the recession, where I would be representing a bank that had loaned millions of dollars to someone to acquire some big pile of dirt somewhere that the people had all these grandiose visions for and never did anything with, but the money somehow got spent on something, and the big pile of dirt is still the big pile of dirt. And basically, the bank sues the borrower, asks the court to appoint a receiver so the bank could get into the property, get it sold, get their money back. That process is great for the bank. It's not helping any other creditor, at least not directly. Other people may wind up getting paid as a result of, like, the property getting prepared to be sold and then sold. But receiverships where unsecured creditors get paid meaningful amounts on their claims are exceedingly rare in my experience, because in the absence of any special priority statute, you're going to go with what priorities are generally under state law, which doesn't vary that much. Like, it's sort of secured, perfected first, and then the bankruptcy code scheme then gets you to taxing authorities and certain employment wages, and then you get down to like junior secured, and then unsecured, and then underneath unsecured are people who own the company, who almost always get wiped in every bankruptcy and every receivership. And then you go to unsecured. Are they going to get something? Maybe, maybe not. And sometimes there are distributions, and the way that you would get paid, Vince, to that part of the question is part of the receivership process. So, and I can do timing on this one to try and do them both. So let's say we go to court, we file a lawsuit, file a motion to appoint a receiver, and there's a hearing, in a week or 10 days or something, and then the court appoints the receiver. At that moment, the receiver is in charge. The receiver is now the sole legal authority, over the assets of that entity. And it's instantaneous. It's like, sign my name, boom, receiver, you're the guy or the woman, the person. And now you're in charge. And you have to figure out, like, or is the business going to stay open? Is it not going to stay open? Are we going to sell it? Are we going to get a broker? Are we going to keep these employees on? Are we going to not? Are we going to sell these vehicles? And so on and so forth. As part of that process, the receiver will eventually establish, this is like generally speaking in most types of receiverships, in most places, the receiver or the court will establish what's called a claims bar date. And then creditors, other parties in interest get notice of that, and also provide a proof of claim form, like in a bankruptcy. And then a creditor or purported creditor sends out their claim, they send it into the address, and then, assuming there are assets in the receivership for distribution to anybody, then the receiver has to go through, usually with the help of counsel, and vet those claims and decide if, are some of them objectionable, let's object. Now, you're really only doing that, to the extent that there's a chance that there are enough assets to maybe pay out some of those people. But that's how that process proceeds. And so you don't really know until you know whether there's money for people. And so you just sort of go through those steps every time, assemble the assets, liquidate the assets. What do we have in the bucket? And now, like, who's claiming what, why, sort all that out. And then finally, there'll be like a final distribution at some point that the court approves, and then the receivership will be terminated. And so, that could easily take a year, like that,
Somebody asked the question. Oh, go ahead. And I'm going to ask the question. Go ahead, Ethan.
Is there a a claims form dictated by law, as well as, when you have to mail it out, how long parties have to mail it back in, or is it just a process you devise with the court's help?
It depends on what your particular state statute or procedural rules say, but generally speaking, it's kind of loosey-goosey. There are sometimes deadlines, by which you have to do a certain thing, but for the most part, the receiver has a fair amount of discretion and leeway to kind of figure things out, get sorted, get information out to creditors. And again, there are some basic deadlines in there, but it's not, at least in my experience, it's not it's not sort of overwhelming. You know what I mean?
Yeah.
Or like overly burdensome. It's the forms are simplistic. They're not even as complex as a bankruptcy proof of claim form, which is itself fairly straightforward. So, receiverships, bankruptcy, those types of proceedings in law are largely about notice and an opportunity to be heard. Like, there is what there is. Like, what's left is what's left, and whoever's going to get it is going to get it, and that's going to be decided, by the court or courts and arbitrators and trustees or what have you. But you can't go back in time and change the scenario, you know what I mean? And so all there is really is the process of evaluating who has, the best claims on whatever there is. It's not generally about returning anything like a 100% recovery to anyone, which almost always includes the parties seeking the receivership, which is another thing that's just worth throwing out there. That party is often seen in different settings by different players to be like the evildoer. But even that player, the party seeking the receivership, is usually taking a massive hit. So it's sort of like everyone is taking a hit. And it's not like, we're equal opportunity lawyers in that, like, we would represent someone on any side of any type of one of these proceedings. But I'm just saying, generally speaking, even the big bad bank or the big bad company going into receivership that may be disappointing its partners, employees, vendors, whatever, they're also likely having a tough time also, because you don't lightly go and pay to put something in receivership unless you really believe that there's no choice, and what you're really looking to do in that instance is try to preserve, especially if you're a going concern and you want to preserve that going concern value. The only way to do that, when you have landlords trying to evict you, taxing authorities, liening you, various other people, coming after you, threatening you, doing this, doing that. The only opportunity that you would ever have to not just go down the tubes then is to be able to stop all that creditor and collection activity, sort through what's going on, typically get a neutral. This is also why you don't tend to see people filing their own receiverships, because a lot of the time, by the time the receivership is warranted, there's not universal agreement among all parties in interest in who is the right person to be making these decisions. And that's why, the court will appoint a receiver that can demonstrate that he or she is in fact not just qualified to be receiver, but is also truly neutral and doesn't have connections with any of the parties, because that neutrality is important, and I think it enables buy-in to the process that you might not get otherwise.
By the way, there's one question from someone: do any of you three attorneys work non-cannabis cases? The answer is yes. I handle primarily, commercial litigation and insolvency proceedings outside of the cannabis context. I know Matt has as well, and I know Vince has as well. So, cannabis obviously raises special issues. Both you can't file bankruptcy, you're forced into a receivership, but that's just one regulated industry, right? There's other regulated industries where you run into issues as well, and you just deal with them as they arise. I had a receivership of a psychiatric hospital in Arizona. We appointed a receiver. We represented the secured party, but the receiver was a financial expert, not a hospital operations expert. And so he retained. We had a stalking horse, which was a large psych hospital provider that was the stalking horse to buy our particular hospital. So we brought them in as essentially the manager, right? They could appoint a chief of staff, right? They could appoint someone to be the director of quality. And that's not the receiver's expertise. So, it's not unusual to have various regulated industries involved in a receivership matter. And again, you deal with those particular issues, as they arise.
So some good questions trickling in. Our friend Sean
I
Clancy
think
asked,
it's funny. I'm
Yeah, you
thinking
wanna
of like
answer that
doing
one?
like running down, do like a game
It's
show
almost like
where it's
speed
like
rounds
really,
that happen.
yeah, totally.
Yeah.
I think we could do a little speed round on some of these. Sean's question is great. I sort of was speaking to it before without being explicit. Sean's question is, if the receivership ends not having paid off all debts, what happens to the unpaid debts? And the answer is they never get paid by anyone. And that's why I think the best answer about like what is a receivership most like is the answer is Chapter 7, because in order to they say Chapter 7 is where companies go to die. And the reason they say that is because it's all over. Like there is no company, there are no debts, there are no owners, there are no creditors. Like it just wiped off the map. And if that wasn't all true, then it would be inequitable, arguably. Like, wait, the company can continue, but I don't get paid? Like that doesn't make sense. Like the equity isn't wiped out, but my debt, which is above that in priority, isn't getting paid. That doesn't make sense. And that's why it's kind of all or nothing. This question about, is there an opportunity to cancel or modify leases in receivership? The answer is definitely yes. That's the flip side to what I was talking about before, which is called assuming an executory contract. So receivers appointed, the company has this great lease, and the people who own the building want us to leave, and we don't want to leave. And so, yeah, the receiver can, if the lease is not in default and the landlord doesn't have certain other arguments to bring to bear, then the receiver can assume that lease and keep paying the rent and be the tenant. But the flip side is that if the receiver doesn't want the lease, it can be rejected, which is the equivalent of you saying canceled. Modifying the leases is an interesting question and isn't really something that the law gives you the ability to do in terms of modify the terms. But the receiver can certainly negotiate with the landlord to get a new lease, and the leverage is, well, if you don't do that, I'll just keep the existing one, which you can't prevent me from assuming. This question about the UCC filing for cannabis receivership, the only relevance of a UCC filing would be what we were talking about earlier, in that if I am wanting to institute a receivership because I am a creditor of your business, then I'm your lender and you're in default, etc. Then I, as the lender party, need to have a UCC1 on file to perfect my interest in your assets as my collateral. But in terms of getting a receiver appointed, there's no UCC angle on that, nor does the receiver have any obligation to, it might arise in some context, but the receiver doesn't go in and start doing UCC filings. So it's really about being in the right position to institute a receivership or assert your rights as a secured party in a receivership that happens, more than anything else.
Once a receiver is appointed, somebody asked this question actually just before the webinar. Once the receiver is appointed, is there a legal time mandated for the receiver to notify creditors? And if it's not executed, that's what they wrote, what can be done? Ethan, I think you've dealt with that, haven't you?
Yeah, well, yeah, I dealt with a similar issue. I had a receivership matter. We represented a secured lender, and it was a hotel, and right next to the border in Arizona, of all places. And the receiver filed their final fee application, and we objected. We thought some of the services weren't provided, and so on and so forth. We went in front of the trial court. We prevailed. The receiver took it up on appeal. The appeals court overturned the trial court and said that if we wanted to go after the receiver, we had to amend the complaint, serve it on the receiver with a summons like any other defendant, which to this day I still find pretty insane. Part of filing a complaint and serving it is, notice purposes. Well, certainly receivers on notice of the receivership and the complaint and everything else. Certainly, they seem to be an interested party. They're being paid out of the receivership estate. But nonetheless, that's how the court ruled. And I think, unfortunately, that opinion has been cited in other states as well. So it's notice is incredibly important in receivership matters. But then the secondary question is, who can you bind to the order in a receivership matter? Is it only a defendant? Is it any party that has notice of the receivership matter? Typically you'll see, at least in Arizona, there'll be a turnover requirement for any third party that's holding assets, let's say, of the debtor. Well, if that party's not named in the complaint, can you still compel the turnover of those assets? So it does raise very interesting issues about notice and the like.
The other thing I'll just say about that, generally speaking, is, and for non-lawyers in the audience, this may sound like a sort of technical distinction that doesn't mean much, but historically, going back to England hundreds of years ago, there's this historical division in the law between like the law or matters of law and matters of equity. And it's an interesting distinction. There's a lot that you could say about it that isn't really super relevant here. But when a court, like a bankruptcy court, for example, is a court of equity. And when a court when a state court appoints a receiver, it's acting as a court of equity. What that's meant to signal is, generally speaking, that there's a greater degree of leeway and discretion in the court inherently for the purpose of doing justice and fairness. And those terms are all squishy-wishy on purpose, because the idea, if you're in a court of equity scenario, is the judge is going to case by case really evaluate who's saying what, who's doing what, who did what, who seems like they're a good person, who seems like they're a bad person. And I should say actor, good actor, bad actor, and then make decisions. And so there's no one rule that this kind of creditor needs this many days or of notice of this kind, or else this happens, because everything is case by case. Everything is subject to the judge in that instance. Like, who's complaining about not receiving notice? What's that person's relationship to the case? What do they actually know? Because if you actually know about it and you're complaining that you didn't receive the piece of paper, in a court of equity, as an example, a judge may not get overly bent out of shape about that. They might say, well, I'm sorry, Mr. Sliwoski, but you didn't know about it, right? You didn't know that the hearing was today, right? Isn't that why you're at the hearing? It's sort of, it's almost like a way of saying there's a common sense quality sometimes to what happens when a court is sitting in equity that you might not see when it's sitting at law. And again, we're not in law school, and I'm not trying to, be impressive or fancy with those terms, but it's important because it really affects, like in Oregon, for example, and I think this is generally true across the board, the court that appoints the receiver is the only court, is the exclusive court that can weigh in on any of those things. I don't mean an appeals court. There can be an appeal related to a receivership, certainly. Maybe not until it's over, but that's a different question. But no other court in the state at the same level can sort of come in and say, no, like you shouldn't have that receivership judge. And so each judge that appoints a receiver actually has quite a bit of power and discretion in a way that subtly kind of goes beyond what most judges might have in like a quote unquote normal, regular sort of lawsuit between two parties for a breach of contract,
All right, I just want to introduce one last concept, and it doesn't come up very often, but there is the notion of a general receiver versus a specific receiver.
It's a good point.
Receiver is someone who essentially takes over the business. If you're a secured lender, you have a blanket lien on all assets. You essentially can take over the business. You have an interest in all the assets. If you have a more limited security interest, or you have a particular reason, you can ask for the appointment of a specific receiver. And a specific receiver is just that. They would oversee and deal with specific asset or assets. And so, it just really depends on a variety of factors, whether you want to request the appointment of a general or specific receiver. At least in my experience, it's always been a general receiver. But I could conceive of instances where a specific receiver would make sense.
Quick question, because we're going to give it short shrift, but we should talk about it. A lot of people watching, or some maybe hemp businesses, right? So they aren't locked into, their creditors aren't locked into pursuing only receivership as far as remedy. They could go to bankruptcy court. Why would a creditor choose receivership over a bankruptcy court if they're doing, let's say, a hemp business or an ancillary business that isn't barred from bankruptcy court?
Well, if you think back to the example I was giving before of a bank during the recession going after property that it had financed for some construction that didn't happen. That doesn't involve anything federally illegal, and the bank tends to choose state court receivership as the first instance, because it, in a way that they say about arbitration, which is sometimes true and sometimes not, like on the whole, people will say that state court receiverships can be easier, slightly less formal, possibly less expensive than trying to accomplish the same thing in bankruptcy. Another reason, and this ties into something that someone asked here in the questions about look-back periods and fraud, one reason that people will stay away from bankruptcy is if they have certain kinds of issues, in their facts that suggest clawback of certain monies, either as a preference payment in the 90 days before bankruptcy, because most receivership statutes don't deal with that piece of it. The bankruptcy code has several different fraudulent transfer related provisions. A state court receiver can use, every state, as far as I know, has its own version of the Uniform Fraudulent Transfer Act or Uniform Fraudulent Conveyance Act. And they're all very similar, and receivers can utilize those statutes a receiver can sue some other entity under the umbrella of a receivership for returning a fraudulent transfer in exactly the same way that a bankruptcy trustee can. So sometimes people will choose state court receivership to have somewhat less formalities, somewhat fewer opportunities for certain kinds of clawbacks, and overall maybe a more inexpensive, less formalistic process.
Just to pick up what Matt said, those actions are collectively referred to as avoidance actions in bankruptcy. There's 4 specific statutes. 11 U.S.C. 547 are preferences. 548, fraudulent transfers, both under bankruptcy laws. You can incorporate state law as well. 549 is turnover of the debtor's assets. And then 550 is the ability to go after subsequent transferees of an avoidance action. So there's 4 statutes that are very, very powerful. At least in Arizona, you don't have that analog in receivership matters. I think some states have adopted preference type statutes. As Matt said, you always have fraudulent transfers under state law, turnover depending upon the order, right, or the statutory regime in your state. But you can accomplish that as well in a receivership. It's just bankruptcy. These things are a lot more well defined.
All right, gentlemen, it's been an hour. Thanks to everybody who came. Thanks for everybody who asked questions. Do you have any final thought? I'll give you 15 seconds. You're good? I thought you were trying to speak, Matt. Okay.
Oh, no, I'm sorry. Yeah, sorry.
Okay, we're going to sign.
We'll do a part 2 at some point.
Yeah, we'll do a part 2, and we may follow up on the blog. A lot of you guys probably found us through the Canna Law Blog, so we may write more or answer additional questions about receivership there. Until then, an email with the link to the replay will be sent to all of you registrants. So in case you missed something, I realize some of this stuff can be kind of dense, and you might want to watch it again at your own speed, but otherwise call us if you're in and around receivership or have those considerations. We're here. We like doing this stuff. Thanks everybody for your time.
Take it easy. Thanks for the opportunity.
Thank you.